Hey guys, so I'm in a hotel, so the Wi-Fi is kind of weird here. So I was gonna stream real quick and show you guys something, but I won't bother with that because I don't think it would go too well. So let me talk to you about something I noticed. Hopefully I'm hearable because I have kind of limited time to do anything extra other than work. So let me show you something that I noticed. Let me share my screen. So please look here. I noticed something. I, of course, was checking on the case because we had our hearing on January 6th, and you can see the minute order putting in that the argument was heard and it's taken under submission. The written decision is to be issued, and if another hearing is necessary, they'll schedule it and issue us a notice. So I'm always checking because it might appear electronically before it appears in my mailbox. But down here, notice it says no court reporter. All the other hearings that we had, as far as I'm aware, for sure on the first one we had a court reporter because I remember Judge Chiarello saying to speak a little bit more slowly for the court reporter, to both myself and Priscilla, because I know why I was so wound up, and then she was even wound up because she was, trying to defend the undefendable, right? So nonetheless, that made me wonder because, some states it's mandatory to provide it. Or if the parties ask for it, it becomes mandatory to provide it. But California, particularly Santa Clara Civil, they don't have to provide it. So they were within their rights not to provide that. And even if I asked, it would be the burden would shift to me to pay for it. So isn't that interesting? So what you can do, though, because I was concerned about that, I wonder, there's no proof then of what I said and what they said and whatnot. And I don't like that. So there are things you can file going forward to get that. But on appeal, what you can do to get it into the record is to draft one of several things. One thing to note, though, is that they may have recorded the hearing. So there's no way to know from looking at the docket. You have to actually contact the court clerk. So I can't do that tomorrow because of the hours where I won't be able to have any time to do something like that. But on the weekend, they're not there. So next week, I'd like to check in and call the court clerk and see. Because, if it's recorded, then that's great. And I would actually put in a request that they be recorded going forward. You can do that. You can also cite that it's a major hardship for a pro se litigant to hire a court reporter, especially for a long litigation like this. So going forward, if we were to go to trial, I would do that. If I go into appeal, there's something I can do. It's called a statement of settlement, I believe, and I can double check on all that. But you basically write out a transcript and you have the judge sign off on it that it is indeed what was said. So that helps you a lot. And, this is just another example of why people dislike what goes on in law, because it's supposed to be about administering justice and being even-handed. But obviously the deck is stacked a little bit against somebody that doesn't have billions of dollars, for example, like a large corporation. Presume that the trial court acted correctly, because all they can do is presume. There's no evidence of anything. What a, ridiculous thing. There should be no question anywhere where there's a proceeding for the sake of justice, especially with all this technology we have. AI, doctors, for example, used to take hours putting in their notes and transcribing things that they recorded and stuff. Now AI can do pretty well with the voice recognition of putting it in there, and they just have to go in there and clean it up and fix it and shave down 5 hours work into like one. So, we've got all this technology and it's everywhere. And look how some of it's so misused, look at the technology being applied to, like, I saw a girl on Facebook doing a bunch of lip syncing videos and making little fake stories with this really incredible software, but they were about nothing. No offense to her, people can do whatever they want, but you see technology being used for crap, and then you think you can't even guarantee that they're going to make a transcript of a court proceeding where there's a lot at stake. So that's the deal with that. But nonetheless, there's things we can do about it. And so just thought that was interesting. I was checking in because obviously, it's been quite a while from the 6th to the 22nd with no verdict being rendered yet. So that was just an interesting side note of discovering that today and noticing that. So, yeah. Oh yeah, I know what else I wanted to talk to you about. So the SSRN is what I'm going to publish something in, a case analysis about the issues in this case and the case itself, and how it ties in also to the new laws being created. What's really cool about all this right now is that, if you get something published in there, not only are you talking about the topic, but you're talking about the case. You're talking about Diane. You're talking about the victimizers who are still out here and what they're doing. And people will have access to that. And there'll be public access to this. Some stuff the public doesn't have access to that's, published in, the legal world. But this is access to the public and to, like the academia legal world, and then also, lawyers and universities and whatnot. So that's really cool. And another thing that would be cool for Diane is that this is a hot topic right now. A lot of things tied into this. That's why all these new laws are being drafted, because, we've had the internet become such an integral part of everybody's lives now that, my generation remembers what it's like not to have it. But there are adults walking around, even adults, that are reaching middle age, who now they've had it with them for most of their whole life, and it's now just considered something that's obviously never going to go away. And we need to start framing up some laws around protecting especially kids, and they know that they're going to have to do that. So and social media companies can no longer have this big out as though they never have to have any responsibility towards society, who have a duty of care. And they're going to have, because of the way that they've tried to get out of responsibility for anything, they're actually going to have a lot less freedom from being liable for things than they would have otherwise if they acted honorably. Now there's going to be law on the books demanding that they act in the case of adults who are placed in harm's way, if they're privy to that. And they won't be able to say, well, we didn't get a subpoena. They're going to say, but once you knew there was an adult being threatened in that manner, and that the threat was, real and serious, like seeing a warrant for someone's arrest, if something happens to that adult, they will be liable because of several statutory laws right now already point in that direction. But they're drafting these bills and these acts to make that even more clearly the case across the board. So anyway, we're part of that with this case, but also, as important, if not more importantly, are the lives of those three people and of anybody else involved in this that would be targeted for harm because they did the right thing. So we're on the right side of history here, and just wanted to make you aware of something that was interesting that I noticed before I, because it'll be a while before I get to make that more comprehensive video about the case analysis. So we'll do that later. I hope everybody stays warm and has a good week. Bye-bye.